What happens if there is no estate plan done by a person who is deceased or becomes incapacitated? Well, the government has already created laws that says what's going to happen to your property, your children, and everything you love if you don't create the plan yourself.
Hey guys, it's Erica Lamar with Huntington Ellis Real Estate Agency. So welcome back to my channel. So today I'm doing something a little bit different on my channel. So I'm actually here with Miss Larissa at Law, who is a top-rated lawyer here in Las Vegas. And I can actually vouch for her personally because she is my lawyer.
Yes, I am.
And she's incredible. So today we are answering the internet's top 5 most searched questions about real estate and probate law. And who else to answer those questions for us than the professional herself?
Hi everybody, I'm Larissa Drohobyczer, attorney at law, better known as Larissa at Law, and I'd love to answer all of your questions today.
All right, so let's jump right into it. So what we're going to do today is we're going to start from the 5th most searched question, and then we're going to work all the way down to the number 1 search question. So let's get into it.
Yes.
Okay, Larissa, so question number 5 is people want to know, why do you need a trust?
Great question, Erica. So I get asked that question a lot too. The reason why a person would need to have a revocable living trust to own real estate would be to avoid probate. And we all know that probate is the court process of transferring assets from a deceased person to a living person. So having a trust is a perfect way to avoid your family having to go to court and be in conflict.
So to tie into that question, what happens if someone does not have a trust?
Wow, so if a person doesn't have a trust and they own the home in their name solely, their family will be forced to go through probate court to transfer that asset in the deceased person's name over to the living heirs. Because since the owner is dead, they cannot sign the deed to transfer the home to living people. So the probate court process is going to be how the home gets transferred, and it is not fun. It's very costly and it causes a lot of delays.
What does that process look like? And especially, like, what is some of the worst cases that you've seen?
Sure. So the first step in a probate process is initiating a court case, which is basically a lawsuit against the deceased person to pay creditors and appoint a personal representative. And the worst case scenario, this process is taking over a year, and if not several years. The worst thing is that as soon as a person dies, all their assets are frozen until the probate process is concluded.
That's lengthy. It costs several years.
Can.
Okay, so question number 4 is, how are a will and trust different?
Oh, that's such a good question. Well, a will and trust are different in the sense that a trust is basically a will substitute, except it does not go through probate court. So when you set up a trust, you create a separate legal entity to hold your assets, and you transfer the assets out of your name into that entity. And then that will avoid probate because it's no longer in a person's name when they pass. Well, a will, on the other hand, has to be probated, and that means opening up that process to transfer the assets from the deceased person to the living heirs.
How do people know if they need a will or a trust?
Well, most people are going to need at least a will or a combination of the two. In order to be a candidate for a trust, their assets need to be of a certain amount, or if they have minor children. The best way to know if you need a will, trust, or both is to speak to a qualified attorney, and do not do any do-it-yourself plans on the internet.
Okay, so what happens if somebody, does their own will or trust, but they don't do it right?
Well, I've been in that situation where we have had to correct do-it-yourself estate plans, and that usually costs thousands of dollars more than getting it done right the first place. And as I tell people, having an estate plan is like retirement. You only got one chance to do it right.
Wow, I didn't know that. I didn't know there was so many intricate details involved in doing a trust correctly.
Yeah, there are, and a lot of people get to do it yourselves, and at the end of the day, usually it's not worth the paper that it's written on because they didn't do the plan right.
So would you say that it can cost them twice as much or even more if they...
Yeah, 2 to 4 times.
Oh, that's a lot. That's quite a lot.
I've seen actually a plan that was done at Nevada Legal Forms, and it costed us about $12,000 to fix that plan.
Wow.
That would have been a few thousand to get done right with an attorney in the first place.
Do it right the first time, and it won't cost you 3 to 4 times later. Question number 3 is, why do some people need to go to probate court and some do not when they're in a real estate transaction?
Okay, awesome. So if there is a deceased seller, if the home is only in that deceased seller's name without a co-owner, beneficiary, or it being in a trust, then that real estate transaction will require probate court because nobody could sign off on the paperwork. Now, in some instances, there may be a deceased owner. However, the home may have been in a trust, and that's how it will avoid probate court. Or there may be a joint tenant, and in that case, the home would pass to the remaining joint tenant who's still alive. Or if there was a transfer on death deed, then probate court is not needed either.
It falls under how you take title.
Exactly.
Question number 2, and this actually had a huge search volume. What happens if someone does not have an estate plan, and how does it affect the children?
Well, that is the best question I've heard because over 60% of Americans over the age of 18 have no estate plan. So if you're watching this and you don't have an estate plan, then you're going to want to listen. What happens if there is no estate plan done by a person who is deceased or becomes incapacitated? Well, the government has already created laws that says what's going to happen to your property, your children, and everything you love if you don't create the plan yourself. So they're all default statutes that will apply if you do not create your own estate plan. So you want to take control, create your estate plan, will, trust, power of attorney, healthcare directive, the whole shebang. It's very, very important for the audience to know that if you are over the age of 18, you do want to get a plan in place.
If somebody does like a do-it-yourself estate plan and they do not do it correctly, the judge and the state can override it?
Correct. There are already laws. For example, if you had no estate plan and you passed away, there's already laws that say who will get your property. And if you're married, a spouse has the highest rights. And if you have children. Now, you may or may not want your spouse to inherit all your property, but that's in the statute if you don't have a plan that you've created and customized for yourself.
So what happens to the children? You don't have a proper estate plan in place. What happens to the kids?
Well, that can be really scary. If there is no estate plan in place and no guardianship nominations, what can happen is the children can be taken into protective custody if something happens to both parents or the custodial parent. So a parent is going to want to have a kids protection plan with guardianship nominations to ensure that their kids never go with the police, CPS, or the authorities.
And we know foster care is definitely not a place for children to be. Our number 1 question that had the highest search volume on the internet regarding trust and probate, and this is actually a 3-part question. Can the state override your trust? Can the state override your will? And does a trust have more teeth than a will?
Wow, that is a 3-part question. So to answer if the state can override your will or your trust, generally no, but there are exceptions, and those exceptions are if you didn't have the capacity or know what you were doing when you executed your documents, or if you were forced to do them, or if you were under the age of 18. Now, does the trust hold more teeth than a will? Yes. Because trusts are private, trusts avoid probate court, and trusts are much harder to contest. So I always recommend that if a person is a candidate for a trust, that they take that extra step and get the trust set up because it will hold more teeth for them if they become incapacitated or pass away.
So I'm going to throw you a curveball question. Now that you've practiced law for several years and you've seen the good, the bad, and the ugly, what is something that you wish the public knew about probate law?
Well, one thing I wish the public knew is that if you do not create a plan, then the state is going to determine who's going to be in charge of you if you're incapacitated, in charge of your children, and where your property is going to go. Most people don't understand that they need to have an estate plan, and you get it while you're young and you're healthy. You don't have to be old. There's a lot of myths that you have to be old, you have to be wealthy, and if you think about your estate plan and dying, then it could hasten the occurrence. There are a lot of misconceptions about estate planning, but I'm here to answer all their questions.
Well, I think you've definitely done a lot by answering the internet's top 5 most searched questions.
Thank you.
If you guys have any questions about transitioning to the Las Vegas market, all my information is in the description below. If you guys have any questions about probate or real estate law in Nevada, Miss Larissa's information is going to be in the description as well. Please contact her if you guys have any questions, and I can vouch for her. She's going to take amazing care of you. Until next time, see you guys in the next video.